Welcome back to the deep dive. I want to start today with a nightmare scenario. And I don't mean a monster under the bed. I mean a real, legal nightmare. Picture this. You're standing on a street corner in D.C. It's a nice afternoon. You're hanging out with a friend, maybe a guy who's a little rough around the edges,
Yeah.
someone with a bit of a reputation.
We all have that one friend.
Exactly. You're shooting dice, just killing time, and then suddenly that friend, he walks maybe 10 feet away, pulls out a gun, and robs a complete stranger.
Yeah.
You didn't plan it. You didn't help. You didn't even say a word. But then the sirens start wailing. Panic sets in, and instinct just, takes over. You run.
And just like that, your life is potentially over.
That is the burning question we're tackling today. In the eyes of the law, are you a criminal accomplice? Or are you just the unluckiest person on the block?
It is a scenario that definitely keeps defense attorneys awake at night. Today, we are going to perform a really rigorous dissection of the doctrine of aiding and abetting. We need to figure out exactly what is required to link a passive observer to a violent crime.
Because to the average person, I mean, to me, honestly, if you're hanging out with a robber and you run away with the robber, you're probably a robber.
And that common sense instinct is exactly what the law is designed to protect against. Our mission today is to distinguish between grave suspicion, which is what you're feeling, and guilt beyond a reasonable doubt. That's what's required to actually put someone in a cage. We're going to look at the taint of criminality from prior association and the surprisingly weak evidence of flight.
Okay, let's unpack this. Before we get into the story of the specific case, we need to lay down the ground rules. What exactly does the government need to prove to tag someone as an aider and abetter? There has to be a specific measuring stick, right?
There is. And we have to start with the general rule, which comes from these huge seminal cases like Nye and Nissen and Hicks v. United States. The courts established a concept called the sine qua non of aiding and abetting.
Whoa, slow down. Sine qua non. You have to translate that one for me.
Sorry, it's a hazard of the trade. It's Latin. It literally means without which, not. So basically, it is the absolute non-negotiable ingredient. If you don't have this, you don't have a conviction. And that ingredient is guilty participation.
Guilty participation. That sounds kind of vague. How do we break that down into something we can actually test in court?
The law gives us three very distinct requirements to prove that intent. To be convicted, the defendant must, 1, associate himself with the venture, 2, he must participate in it, as in something that he wishes to bring about, and 3, he must seek by his action to make it succeed.
Associate, participate, seek to succeed.
Correct. And if you miss any one of those three, you do not have an aider and abetter, you just have a witness with a very bad view.
Okay, I think I've got the theory. But theory is easy. Real life is messy. So to see how this plays out on the pavement, we are going to deep dive into a fascinating case from the D.C. Circuit Court of Appeals, Bailey v. United States.
This case is the absolute gold standard. It forces us to look at the totality of circumstances, presence, friendship, and running away, and ask, does that equal guilt?
Let's analyze Bailey v. United States. First, what are the legally dispositive facts?
Right. So it's the afternoon of September 26, 1966. We are in Washington, D.C., near the Center Market Provision Company. It's a busy sort of industrial area. The appellant, a man named John L. Bailey, is just hanging around.
And he's not alone?
No, he spent the afternoon shooting craps, playing dice across the street with a short, stocky man. Now, the court record is very mysterious here. They refer to the second individual simply as the other man.
The other man. That sounds like a villain in a noir film.
It really does. So Bailey and the other man are playing dice. At one point, Bailey leaves, plays a quick game of 5 and 10 cent crap with some other guys, and then comes back to the other man. They eventually walk over to a parking lot and stand by a truck that's owned by the Center Market.
So far, this just sounds like a boring afternoon. They're just hanging out. Who's the victim here?
The victim is Wilson C. Lawson, Jr. He is a bookkeeper for the market. He walks out carrying a paper bag that contains a deposit, a lot of cash, approximately $4,200.
In 1966. That is a massive amount of money.
It's huge. So as Lawson walks toward his car, he sees Bailey and the other man standing by the truck.
And what does Bailey do at that moment? This seems like the crucial point.
Here is the critical detail. As Lawson approaches, Bailey walks away from the other man toward the curb. He stops about 10 feet away. Then, the other man pulls a gun and robs Lawson of the deposit money.
Wait, Bailey walks 10 feet away right before the gun comes out.
Yes.
I have to be honest, that looks like a setup. It looks like he's giving his buddy space to work, or maybe acting as a lookout.
It certainly looks suspicious, but let's finish the sequence. A bystander, another truck driver, yells out, "Look, they're robbing him." And immediately, both Bailey and the other man run away. They run in the same direction.
Of course they do.
Bailey was eventually caught by the police. The other man, he was faster, he escaped, and was never identified.
Yeah. And the money?
Gone with the other man. When they searched Bailey, he had no stolen money on him. He didn't have a gun. He just had himself.
Okay. And what was the core legal issue?
The legal question was this. Was the totality of that evidence, his presence, the prior association, and his subsequent flight, was all of that legally sufficient to sustain a jury finding that Bailey aided and abetted the robbery?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
They went right back to that Nye-Nissen standard. The rule has 3 elements regarding the defendant's intent and action. First, he must associate himself with the venture. Second, he must participate in it as something he wishes to bring about. And third, he must seek by his action to make it succeed. And they added a supplemental rule on presence. Presence must be culpable, meaning it's intended to encourage, facilitate, or stimulate the crime.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, association and presence?
Okay, this is where the court starts splitting hairs, but for a good reason. The sub-issue is whether just standing nearby with a friend who commits a crime counts as associating with the venture. The court found that Bailey's presence was, and this is their word, unelucidated.
Unelucidated. There's another $10 word for us.
It just means unexplained or ambiguous. The court said that mere presence, even with a friend, isn't enough unless it is specifically designed to sanction or promote the robbery. Looking at the facts, Bailey was in open view. He wasn't hiding. There was no evidence he helped plan anything, no evidence he signaled the robber, no nod, no wink. And crucially, he didn't share in the proceeds. So their conclusion on this element was that mere presence, even with that prior association, is insufficient to prove he associated with the criminal venture.
Understood. Now, what about the second element, participation, especially regarding the issue of flight?
Right. So the sub-issue here is, does running away when a crime occurs prove participation, or what lawyers call consciousness of guilt? The rule they applied was a modern one. They basically rejected that old biblical notion that the wicked flee when no man pursueth as a legal absolute. Their analysis was that flight is just too ambiguous. Innocent people flee. They flee to avoid being a witness or out of fear of the guy with the gun. And applying the facts here, Bailey had a prior criminal record. That alone might have motivated his flight purely out of self-preservation. There was no firm foundation, as they put it, to attribute his flight to this specific robbery. So their conclusion was that flight alone cannot transform mere presence into guilty participation.
And after analyzing all the elements, what was the court's final conclusion?
The conviction is reversed and remanded for acquittal. He walked. The court synthesized its logic by calling the government's case fragmented. Without proof of collaboration, of looking out, or of planning, the jury was left to speculation. And you can't convict a person based on a guess. Now, there was a dissent. Judge Bastian believed the totality of it all, association plus presence plus flight, was enough for a reasonable mind to infer guilt, but the majority held that grave suspicion is not enough.
This brings up a really difficult boundary for people to visualize.
Yeah.
I want to cement the difference between presence and aiding for our listener. Can you give us a hypothetical, something visceral so we don't forget it?
Absolutely. Let's visualize the silent butcher hypothetical.
I'm already scared. Go ahead.
Okay. Imagine you are standing inside a meat locker. It's cold. In front of you, a brutal, bloody assault is happening. Your best friend is beating someone up. You are watching it intently. You do not leave. You don't call for help.
So I'm just watching my friend commit a crime.
You're just watching. And here's the twist. Unless you block the door to prevent the victim from escaping, unless you shout, "Hit him harder," or unless you hand the attacker a meat hook, legally, you are just a witness.
Even if I'm secretly cheering for my friend in my head, even if I'm thinking, yeah, get him.
Even if you enjoy the show, your internal state doesn't matter. The law doesn't punish thoughts, it punishes acts. Without an overt act of assistance, you are not an accomplice.
That is wild. It feels morally wrong, but I get the legal logic. Now, flip it. What's the one small thing that would make me an accomplice in that meat locker?
Change one tiny fact. You're standing there watching the beating. You see a security guard coming around the hall. You cough loudly to warn your friend.
Just a cough?
Just a cough. Because in that split second, you have associated yourself with the venture, and you've sought by your action to make it succeed. That single cough transforms you from a silent spectator into a felon.
That is a terrifyingly thin line. A cough versus silence.
It is, and that is why the elemental analysis we did on Bailey is so critical. You cannot just look at the vibe of the situation. You have to hunt for that specific act of facilitation.
I want to make sure our listener can take this logic and apply it. Whether they are taking an exam or maybe even serving on a jury, can you synthesize all of this into a checklist, a way to diagnose an accomplice?
Certainly. Let's call this the complicity diagnostic checklist. If you're looking at a suspect, just run them through these 5 points.
All right, point number 1.
Check for overt acts. First thing, did they actually do something? Did they plan? Did they signal? Did they drive the car? If the answer is no, you need to proceed with extreme caution.
Okay, point number 2.
Analyze presence. Is it unelucidated, just standing there, like Bailey? Or is it designed? Designed presence means you're standing in front of the door to block the exit. Mere presence is never enough.
Point 3.
Scrutinize association. Is the relationship casual, like gambling buddies? Or is it conspiratorial? Remember, in Bailey, they met in open view. Open view suggests innocence. Whispering in a dark alley suggests guilt.
Point number 4.
Evaluate flight. This is the big one we discussed. If they ran, is there an innocent explanation? Do they have a prior record? Are they just scared? Flight is not a confession.
And the final point, the safety valve.
The speculation gap. This is the most important one. If you, as a juror, have to guess what the defendant's role was, if you have to fill in the blanks with your imagination because the evidence just isn't there, you must acquit.
Right.
The law does not allow convictions based on guesswork.
That is a powerful framework. So
Yeah.
to summarize what we've learned today, you can gamble with a robber, you can stand next to a robber, and you can even run away with a robber. But unless you actually help the robber, you aren't a robber.
That is the law. It protects the innocent bystander, even at the risk of letting a savvy accomplice escape. It is a trade-off the judicial system has decided is necessary to prevent locking up innocent people just because they have bad friends.
It really highlights that the burden of proof isn't just a catchphrase. It's a shield. It's not about what probably happened. It's about what the government can prove happened.
Exactly. And it raises a final provocative thought for you to mull over. We're taught from kindergarten that you are who you hang out with. We judge people by their company, but the law demands that we judge them only by their actions. It forces us to ask, are we comfortable with a system that lets a guy like Bailey walk free just to ensure that you or I don't get convicted for being in the wrong place at the wrong time?
That is a thought that will linger. Thank you for walking us through Bailey v. United States. It's a masterclass in the presumption of innocence.
My pleasure. Keep your friends close, but maybe keep your distance if they start reaching for a weapon.
Solid advice. And thank you, our listener, for joining this deep dive. Until next time, keep questioning the evidence.
Goodbye.